Hello, my name is Darren Allen. I'm a partner at Shoesmiths, and welcome to the first podcast in our 8-series podcast about compliance and risk management. I am delighted today to be joined by my partner, Hayley Saunders, to discuss the compliance and risk management offering. So why have we launched our compliance and risk proposition? Well, in our recent litigation risk survey of 360 GCs and senior lawyers within large businesses, 50% of respondents stated that they had been involved in regulatory disputes in the last 12 months, making it their most commonly occurring type of dispute. And the increasing complexity of managing compliance across areas such as financial services, data and privacy, ESG, competition, employment and consumer protection means that it's never been more critical to adopt a strategic approach to managing risk. So in response to this, Shoesmiths has launched a compliance and risk offering which looks to provide clients with assistance around the regulatory life cycle. So, Hayley, what do we mean by compliance?
Gosh, what an answer to a question. And I think the answer to that question depends on who you ask. And we know from our different disciplines and our areas of expertise that I'm sure, Darren, if you were to ask one of your clients what compliance means to them, you'll probably get a very different answer to the one I would get if I asked one of my clients. So I think what that demonstrates is that compliance means very different things to different organisations, different people. It means different things depending on what stage of your compliance journey you're at. Some clients are very sophisticated, some are startups and understandably have no systems in place whatsoever. So one of the things I think we've definitely learned over the years is that compliance generally, or the environment in which our clients operate, is quite technical. It can be quite complex. There is a lot of legislation. Some is mandatory. There's a lot of other guidance out there that is voluntary with an expectation to comply with it because you are an organisation that wants to do the right thing. So it encompasses so much in terms of compliance. So what we wanted to do at Shoesmiths was bring all of that together so we had an offering for clients that brought together the expertise of different people, different teams, different sectors. And the beauty of doing that from a holistic perspective is that you can provide assistance and guidance and advice on all of those areas, depending on where in their compliance cycle the client is or the business is.
Yeah, it seems to me that it's compliance with legal and regulatory requirements. But as you say, it goes further than that in the sense that it looks at best practice within particular industries, for example. But it enables us to have conversations with clients that are not siloed. Yes. So, as a litigator, I don't need to talk about purely litigation. I can talk about other risks that the clients have, and we can then talk about how we can assist them in dealing with those particular risks.
One size doesn't fit all, and we definitely know that from the variety of clients that we act for. And we can have many conversations together, can't we, as we can with other members of the Shoesmiths team where we'll be acting for a client. It might have a criminal regulatory aspect to it. We have a conversation, suddenly you've got a potential reporting requirement. Depending on what it is, it can touch upon so many different areas, and it's important that it's all considered together at the same time, because you make one decision at one end, it can have an impact on something later on. But that's the beauty of compliance. But you're never going to find one person that will be able to have all of the answers to those questions. Certainly from our client's perspective, you get compliance officers, but their role just touches so many different complicated parts of the business. And that's why you have to have so many stakeholders involved in terms of managing that risk across the whole business.
Yeah, because if you don't do that, if you do have a silo approach, it's incredibly dangerous.
It is.
You can go down one road and have a perfectly good, investigation strategy, for example, and discover that it's caused all sorts of issues on the regulatory side.
Absolutely, you can't be blinkered with your approach. You have to have a broad approach. If you're, as you mentioned there, doing an investigation, you will have terms of reference and you'd have a scope for that investigation. But you can't be narrow and fixated with that. It might be that a question you ask leads to a different answer or an answer that you weren't expecting, and suddenly your scope has been widened. But the beauty of consulting many stakeholders within the business and then consulting lawyers who have specialist expertise in terms of assisting you with compliance is that hopefully you can spot those issues at the outset, so you're not going down a a one-track road with any investigation. You're looking at it from a broader perspective and therefore baking in all of the risks that might come into that as part of looking at what the compliance issues are.
Okay, so why don't you and I just walk through the offering, because then we can bring it alive for listeners. We're, on our website, we've got the compliance risk wheel,
Yes.
which takes you through various aspects of the kind of regulatory cycle. Should we start with horizon scanning?
Yeah. Yep, absolutely. So we've got a wheel, and it's dependent on where you are in your compliance journey. You could enter the wheel at a very good proactive stage. You know, we want to make sure either we've got good systems in place, or what we have got is mature enough to guard against the risk, or you could come at it from the reactive perspective, which nobody really wants to be in, but you're off the back end of some litigation or a complaint or enforcement action, and you've got to turn the corner. But one of the common questions that we get asked by clients is, how do we stay on top with everything compliance related? So for a start, you've got to get to the nub of, well, what is the compliance issue that you're concerned about? What we wouldn't want to do is provide a client with reams and reams and reams of paper, registers, lists of legislation, then expect them to go through it all and work out what might apply. It's looking at what your material risks are, but knowing what's enforced, knowing what's coming down the track from a sort of a 6 to a 12 month perspective, applying some risk analysis to that. You know, how important is it that we know about this and comply with it? Because what is the risk if we get it wrong or don't comply? They are all really difficult questions for a business to be able to answer. And what we want to do is provide clients with assistance in terms of identifying what that legislation is, or consultations that may be out there in relation to new legislation, so you can best prepare yourself to put in place the compliance measures to ensure that you're compliant going forward.
Yeah, and I suppose a recent example of that is the failure to prevent fraud offence, which we had the guidance a couple of weeks ago. We're now recording this at the end of November, but that provided guidance, and the adequate procedures must be in place, and the legislation comes into force in September next year. So that's a perfect example of where we track the legislation, we keep clients informed as to what's happening, and then we advise them on how they can comply with that legislation and the requirement to have in place, adequate procedures.
Absolutely. And other areas where we've assisted clients could be in relation to ESG, so non-financial mandatory reporting. So you'll have certain triggers in terms of whether that's the turnover of a business or number of employees, whatever the threshold may be, it may trigger an obligation that requires mandatory reporting. And sometimes you can be looking at a compliance year that's a year in advance or in arrears, so you need to be able to collect the data so you can submit the data before the relevant, reporting requirements. So similar to what you would have in financial reporting in terms of, filing your accounts, for example. We're now seeing a whole stream of ESG legislation, predominantly on the environmental side, for non-financial mandatory reporting.
Yeah. And then you have the embedding compliance. So you've had the legislation or the regulatory change.
Yeah.
You then embed that in terms of policies and procedures and training to ensure, I think, that you instill the right culture within a business.
Absolutely.
So it's all well and good having a compliance policy, but it's important to make sure that it's properly implemented and people understand what they should and shouldn't be doing.
Yeah. And we've all seen that, haven't we, where something's happened or it's gone wrong or there's been some sort of intervention or investigation, and you can look at the policy and procedure and you've got something in place that's in writing, and that's all brilliant. How dusty is it because it's been sitting on the shelf for too long? Yeah. Has it been adequately implemented? Is it too complicated? Is it too detailed? Is it too wordy? Is it not easy to be understood? And how do you get the message across from the policies and procedures through to your staff? Because in relation to implementation, they need to understand what those procedures say. They need to follow them. They need to be involved, potentially consulted on them.
Yeah.
And then if they're not working properly, you want that, again, another wheel, you want that to be fed back to the business in terms of the monitoring, the review and the audit, because there's no point implementing something if it's not going to work in practice. Yeah. And there's no point having a policy or procedure drafted if it's incapable of being implemented.
Yeah, I agree.
And the training, whether that's training at board level in terms of responsibilities and liabilities or from an operational, practical perspective, it's really important. Yeah. And you've got to take everybody on the journey.
Yeah.
You haven't you? It's the hearts and minds piece, not just the legal and the ops.
Yeah, no, I entirely agree. In addition to embedding compliance, we also have, we have always had and will continue to have a stream of kind of immediate requests for advice.
Yes.
An issue has arisen. Can I sense check something with you, or can I check whether I should be doing something? And I think that is a necessary part of our offering. It has been forever and will continue to be so.
Yeah. And again, the beauty of that is that if that's done at a proactive stage, so here's the new legislation or here's the consultation that's out there, what does that mean to our business? It doesn't deal with this particular issue that's unique to our business. Of course it doesn't, because the legislation doesn't cover every area and the guidance then doesn't support it. So as lawyers, you start to sort of nibble around the edges of what it might mean to the business. But taking that proactive advice when you're in a position to have time on your side, which is really important. Again, consulting with the right people, trying to understand the impact it's going to have on the business and what you need to do about it. Is it sufficiently material enough to sort of come at the top of your priorities, for example? So all of that advice, yes, we help clients with all the time. And, if it can be proactive advice, so you're not coming off the back of an investigation or, you're not time pressured, that's the best position to be in.
Yeah, I agree. And then sadly, sometimes there's a crisis. And I think the key here is, it may not be possible to avoid a crisis, but the key is to have a plan in place. In many ways, it's linked to investigations, because it's important to have a plan in place for investigations as well. But how do you deal with a crisis? How do you deal with investigation? How do you engage with stakeholders, media, insurers, regulators, and so on? It's important, I think, that firms have a very clear understanding of what they should be doing at those points in time.
Absolutely. And, it goes back to, as you just said, you could have a policy in place for dealing with that. And that is all great, and you want that to be effective if you are in a time of crisis. But again, if you are in crisis mode, more often than not, you don't have time on your hands, or everything is pressured. You're having to deal with issues in such a short period of time. So what you don't want is that opportunity to be the first time you think, gosh, who do we need to consult with? Who are our stakeholders? Who do we need to speak to in the business? If somebody's out of the business, who's our second port of call? All of that stuff. And if you can think that through by virtue of an incident response policy in advance of your crisis happening, brilliant. And then if you can enact it by having a bit of a mock procedure, whether it's a dawn parade procedure or somebody's turned up, what do we do? And you can test it out to see the strength and maturity of that system. Sometimes crisis management policies come off the back of dealing with a crisis, and it happens as part of the debrief. What worked well, what didn't.
Absolutely.
And you come at it at different times, don't you? But again, the more you can front load that to have all of those considerations and those questions asked in advance of a crisis happening, the best position you can be in. Consulting the relevant teams, we would consult the relevant teams here at Shoosmiths. If you had a criminal regulator turn up on your doorstep, that is very different to having a civil regulator. What do you need to do? There might be mandatory obligations in terms of reporting. Do you say something? Do you know all of that stuff? You don't want to be making quick decisions about that.
No, I think also that bit about making disclosures to the market, communicating with stakeholders, both internally and externally, and the media bit as well. I mean, I'm probably going to make no friends with lawyers listening to this, but I don't think lawyers are necessarily the right people to turn to when dealing with the media. You would deal with a media affairs company that really understand how to deal with particular issues, and it's having all that in place, which makes it a lot easier to deal with a crisis.
It really does. And I always think on that, there's no right or wrong decision in terms of media and comms and how you communicate to the market or your customers. It is all very subjective to what you're dealing with. And if you've got a team of stakeholders, you've got appropriate challenge and you've got the right level of expertise, but you don't want to just have one person that's going to answer all of those questions. That's a lot of eggs, in my view, in one basket. But I completely agree. You want people who are dealing with the media all the time. They know how things work. They know how you can present a message. And that's really important. But they all form part of your crisis management team.
Exactly.
We're all in it together.
Yeah. And then there's the investigations bit, which I've touched upon. Are you able to swiftly investigate? A lot of the same considerations. How do you deal with stakeholders? How do you deal with employees? Your response to an investigation, whether it's an external one from a regulator, or law enforcement, or an internal investigation, there needs to be a plan in place. And we can we can readily assist clients with those kind of investigations through the experience that we've gained over the years.
And it's good to have a plan, but again, stay flexible. So you have your key things that you'd always want to include, making sure you've convened the right team and your terms of reference, the scope, what you're trying to achieve. But you don't want to have such a fixed and rigid template that you feel like, you've got the blinkered approach again. You need to be thinking of the wider considerations.
Yeah.
But again, the extent to which you can plan that in advance, were we to have this issue, this is our rough plan for how we would conduct that investigation.
I agree. And then, despite dealing with a crisis and despite an investigation, sometimes you have to defend and protect.
Yeah.
Litigation, criminal proceedings, regulatory proceedings. And again, we've got a very significant amount of experience of dealing with those kind of issues.
Yeah. And, nobody wants to find themselves in court. And as lawyers, we don't want our clients to find themselves in court. That's always the last chance saloon, isn't it? If you can resolve anything by way of informal or formal enforcement action before you even get to court, brilliant. It's not all about lengthy trials or protracted litigation. Sometimes it's a guilty plea and it's damage limitation. It's making sure that you can reassure the court, the regulator, whoever else, the stakeholders might be, that you won't be finding yourself in this position again. And then that comes back full circle on the compliance wheel to what have you done in terms of remedial measures?
Yes.
Sure it won't happen again.
Yeah, absolutely. And then finally on the wheel, there's a reference to good governance or governance. And in every investigation that I've been involved in, it seems to me that the reason why the problems occurred in the first place it usually breaks down, in part at least, to a failure in governance and a failure in culture. And culture, I kind of link with governance anyway.
Yeah.
It's senior management, the board not having an oversight over something, or it's the three lines of defence not working coherently together. And so I think, having an understanding of governance, testing your governance and ensuring that it's effective is actually a critical measure in stopping a lot of the issues that we've discussed already.
Yeah. I think that's really important. And you've got to challenge and be ready to challenge when things aren't working properly. Don't stick with how we've always conducted board meetings or how we've always done our training or how we've always implemented a new project, whatever it might be. Really challenge as to whether that's effective, because you're right, you need everything from top level commitment, board level commitment, through to operational staff that are building the widget or working on the shop floor, whatever it might be. And as soon as you've got a disconnect between those people and those channels of communication, we've all seen it where a question would be asked of a director, top level commitment, we're really committed to doing this, that or the other, and then you speak to somebody else right at the other end of the J and you get a bit of, the board might pay lip service to this, but it isn't really what happens in practice. Nobody wants to be in that position.
No, absolutely. I think that's our time up, Hayley. Thank you very much for your insightful comments. I think we've gone around the wheel effectively, explaining what each component part means. For our listeners, if you want to find out more, then please visit our website where you can learn about our compliance offering, and you can also listen to each of the podcasts in this series. Thank you for listening.